Please be seated. Court now calls case CACV 130625, Johnson Utilities LLC et al. Versus Swing First Golf LLC et al. This is the time set for oral argument. Counsel, you each have 20 minutes to present your argument. There's a clock on the podium in front of you to keep track of your time. Counsel for appellant. How do you pronounce your name, counsel?
Anu Pateja, Your Honor.
Pateja? Mr. Pateja, you can reserve 5 minutes or whatever you want to for your rebuttal. Keep in mind that there's a audio-visual recording of these proceedings, and we upload that to our court website. So these proceedings are things that people can watch if they go on our court website. We have reviewed your briefs. We've looked at the case very carefully. We've conferenced the case, so we're very familiar with the issues in the case. Counsel?
May it please the court. My name is Anu Pateja. With me is Michael Kitchen. We are attorneys for Johnson Utilities, LLC, as well as the Club at Oasis, LLC. I'm going to try to focus my comments today on a few key areas, and I will try to reserve a few minutes for rebuttal. The first thing I want to talk about is this jurisdictional issue, and I think that Swing First has maintained throughout this case that...
Well, let's step back.
Sure.
Your client filed a lawsuit. If you didn't have jurisdiction, why wouldn't you guys get tossed out from the start and then everybody go to the Corporation Commission? Instead, you said breach of contract for not paying your water bill, and they said, we've got these other issues, and they get tried. And yet, now you say that the court didn't have subject matter jurisdiction over a breach of contract claim.
Well, and that's a fair question. The biggest distinction there is the nature of what the relief sought was and the nature of the underlying action itself.
But didn't, in fact, that all get squared away, that what the jury decided was, in between the two trials, took care of legal issues as opposed to rate issues?
Well, and I don't think that's the case. I think that when Johnson Utilities initially filed this lawsuit, it was simply a collection matter. It was one company, a customer, who owed money to the company for utility services. That's not a rate-making issue. It's not a policy issue. It has nothing to do with the powers that are reserved for the Arizona Corporation Commission. Okay. What transformed this case into a case that only should have been heard with the Arizona Corporation Commission is Swing First's position, and the position asserted throughout this lawsuit, which is it's entitled as a matter of right to certain effluent deliveries versus any other type of irrigation water deliveries. That's what transforms the case from a simple breach of contract matter to a case where Swing First is actually seeking affirmative policy relief, not just simply a matter of money damages. When you look at, and I'll direct the court to the trial exhibits in this, I think are pretty clear as to what Swing First was seeking from the jury. If you look at trial exhibits 26, 27, and 29, all three of those set forth the remedy that Swing First was looking for the jury to award. In all of those exhibits, the damage analysis presented by Swing First is simply Swing First took all of the deliveries and all of the usage that they had over the course of this case and the subject period, and asked the jury to calculate their damages based on if they had either, one, only received effluent deliveries, or two, had only been charged for effluent deliveries. Neither one of those things is a jury question. Whether Swing First is entitled as a matter of right to effluent deliveries is not a jury question. That's what transformed the case into a policy case and a rate case versus a breach of contract case. And Swing First will maintain that this is a breach of contract case. From Johnson Utilities' perspective, it's not. It's a case where they've come in and sought affirmative rate relief from the jury.
Now, didn't they ultimately, at least as I understand the record, pay for whatever they had received over time?
Well, and that's certainly subject to dispute. In the first trial, Johnson Utilities had an affirmative claim where they received a jury verdict on amounts that the jury believed at that point were due and owing. In the second trial, Johnson Utilities wasn't afforded that relief from the jury. So certainly Johnson Utilities did not receive affirmative relief at the second trial. But that's not to say that Johnson Utilities concedes that it's been paid for the deliveries that were made. In this case, Swing First has never disputed the amount of water that was delivered or the type of water that was delivered. They've only disputed as to whether they are entitled as a matter of right to receive effluent versus some other kind of irrigation water. And that I think is the real crux of the matter and how the Arizona Corporation Commission and its expertise comes into play here. If a jury is entitled to decide policies and rates, that becomes problematic because they don't have the requisite experience that the Arizona Corporation Commission does.
Was there a special verdict where the jury had to resolve that issue?
I guess I don't think that there was a special verdict saying, is this a matter for the Arizona Corporation Commission?
Or that, Swing First was only entitled to effluent because of whatever.
Sure. No, and there was no special verdict form as it related to whether they were entitled to effluent. But if you look at the damage analysis and what Swing First has requested throughout the course of this case, and in fact, we've cited in our brief all of the testimony from Swing First representative relating to what relief they were seeking in this case. And if you look at that specific testimony, the question that we asked Swing First was, you can't enunciate any you can't point to any policy, rule, guideline, contract that would entitle you to effluent relief. That's correct, right? That's right. And then the follow-up question was, but that's what you're asking the jury to award you in this case, is to give you that right to only get effluent or to only pay the effluent rate. And the Swing First response was, yes, that's what we're looking for. That's what we want from the jury. So while there was no special verdict form, that's in effect, that's the relief they sought from the jury in this case. Now, as it relates to the unjust enrichment quantum merit claim, the real error in this case as it relates to the trial court and Swing First burden at the trial court, it was required to show that it provided services and calculate a value, a reasonable value, or the cost of the services plus a reasonable rate of return at the jury trial. It didn't do that. All it did is it referred back to a prior agreement, the Oasis Management Agreement, and rather than try to establish an independent value for any services that it provided to the Oasis, it simply referred back to the contract price, which the court had previously deemed illegal and unenforceable. Now, Arizona has stated in an unjust enrichment claim or a quantum merit claim, a party has to meet their burden of showing the value of the services that it provided, and where a contract is illegal, you can't simply defer to the contract price. And the policy behind that makes sense. The policy is if you're entering into an illegal contract, you shouldn't then be able to come back later and sue on that illegal contract because that provides a bad incentive for parties to enter into illegal contracts. If there's no relief under an illegal contract and the only price term that you can come up with is the price that's in the contract, that's not enough under Arizona law. That doesn't get you over the burden of proving your damages in a quantum merit claim.
Well, isn't that some evidence?
There's,
and then it's either accepted or rejected as to its true value?
well, what they provided was simply evidence of the types of services that they offered. Swing First had its representative testify that it provided certain services, lawn keeping, clubhouse maintenance, clubhouse management. But there was never any established testimony from anybody as to what the value of those services are, or the cost of the services to Swing First plus a reasonable rate of return. And that, as enunciated by Arizona courts, that's what you have to do in order to succeed on that claim. You can't simply refer back to an illegal contract and say, our illegal contract said I'd be compensated in this amount, and that's what I want from you, jury, which is exactly what Swing First did in this case.
Well, isn't that some evidence of at least that portion of the agreement that the court otherwise said was a legal contract, irrespective of the, everything else they may have been required to do?
I don't think Arizona law says that you can use that as evidence of the value of the services. And I think there is a distinction between illegal contracts and potentially unenforceable contracts. And I think the fact that the court in this case, the trial court in this case, specifically ruled that the Oasis Management Agreement was an illegal contract, not just an unenforceable contract, but illegal, and illegal because it's contrary to public policy of the state of Arizona.
But counsel, what if they just use the contract in the following way? I understand we don't have a contract, but this is what he told me he was going to pay me. That's how the contract is used. This is what he said. He was going to pay me for his services. It's not an enforceable contract. I'm not asserting it's in a contract. This is a memorandum. It's a written document that reflects what he told me. It's not admissible for that purpose?
If the contract and the terms are illegal, I don't think it is. If we take your hypothetical
Take
and
the word contract off the top of it. Just use it as a piece of paper that's written down what you told me you're going to pay me. Is that admissible?
well, I don't know the answer to that question. I think
You don't know the answer to that question?
probably it's admissible for that limited purpose of showing this is the discussion between the parties.
Isn't that why this was admitted?
I don't think so. I think this was admitted to demonstrate the value from Swing First perspective as to what they ought to be compensated under the services they provided, rather than meet their burden of showing what the value of the services were independent of any discussion they had with Johnson Utilities.
If that was what they were doing, trying to meet their burden, then wasn't it then incumbent upon Oasis to say, they didn't, not only didn't they meet their burden, they didn't do that stuff?
We did elicit testimony relating to those issues at trial, both related to what specific service were provided and whether they actually resulted in any value to the Oasis Club. We elicited testimony from Swing First representative on exactly those issues. Now, in terms of, Johnson Utilities and Club at Oasis were defendants in this claim as it relates to unjust enrichment, quantum Merowit. And so obviously the burden rests on Swing First to show the independent value and alternatively the cost of the services plus a reasonable rate of return. That's what Arizona law requires from a quantum Merowit claim. And that didn't happen in this case. Now, if we go back to your hypothetical about some discussion between parties, it eliminates this concept of, in this case, the court explicitly found any discussion or agreement relating to water credits or free water is illegal. And that really is a big distinction in this case.
Did the court rule that the contents of the agreement were inadmissible for any purpose whatsoever?
I don't think that happened because obviously it came into evidence, but I think that's one of the legal errors we're claiming is that contract shouldn't be admissible for purposes of proving Swing First damages. I'm going to move on to the attorney's fees issue because I think it's a key point in this case in terms of how all of this ends up. The biggest point from our perspective is related to the issue of whether Swing First is even entitled to an attorney fee award relating to their claims, which they've entitled breach of contract. But as we've set forth in the briefs, I think in reality what these are statutory claims, and in fact they're titled breach of tariff. And a tariff obviously is something that is mandated by the Arizona Corporation Commission. It arises as a matter of law from statute, not from some independent contractual duty owed from one party to another. So in this case, what we have is, while Swing First was awarded some money at the end of each trial, the underlying claim is really a statutory claim. There was no separate duty that Johnson Utilities owed under some contractual arrangement to Swing First that would give rise to an attorney's fee award. We've cited all the case law in our brief.
Isn't really the breach of tariff And you stated it really, at least from Johnson's start of the litigation, a collection matter between a utility and its customer. And all I think Swing First was saying is for the water that you provided, you overcharged. And so really it's still a breach of contract based upon, and the tariff is just set by the Corporation Commission.
Sure, but again, it is a legal duty that exists regardless of the parties' agreement with one another. It's a duty that's set by the Arizona Corporation Commission, and that takes it outside of this separate legal duty that we generally tend to look at to determine whether something arises from contract, some separate duty that arises from contract. In this case, what we have...
But isn't it a contract that between a utility and its customer, you'll give me water, I'll pay for it, and you'll charge me fair rates?
Sure, it's an implied contract at law. I don't have an issue with that. I don't think that's a leap to make that. But I don't think that given that implied contract at law relationship, that somehow gives rise to separate contractual duties that aren't outside the Arizona Corporation Commission's tariff rates. I want to talk briefly about the concept of the tort damages, which Swing First is seeking in its cross appeal. As set forth in our briefing, there really is no case law that would support this type of tort damage relationship to a case like this. Here we have basically a commercial transaction between one company and another company. The Rawlings case, which Swing First has cited in its brief to support the concept of allowing tort damages to proceed in this case, is an insurer and insured context. And that is a very different context where the purchaser of insurance, the sole reason that they buy insurance is for the protection from some sort of economic catastrophe. In this case, we basically have a commercial transaction between two parties, and at the end of the day, I don't believe there's any evidence to support any kind of a special relationship, no fiduciary relationship. Arizona cases have basically said that in order to find a special relationship or a confidential relationship, there has to be some heightened relationship between the parties such that they're either agents of one another, there's a professional relationship, or some sort of family tie. And none of those have ever really been contemplated in a context between a utility and its customer. For now, I'll stop and I'll reserve the remaining time for my rebuttal.
All right, thank you, counsel.
Thank you.
Mr. Marks?
May it please the Court, I'm Craig Marks, and I'm representing the appellee and cross-appellant Swing First Golf, LLC. I'd first like to talk about our response to the appeal by Johnson Utilities, and then we'll get to our affirmative claim that we're making based on the Rawlings case. And I think I'll go through what I've written down, and then there's just a few matters here that I'd like to respond to. Overall, Johnson Utilities raised 13 issues on appeal, I guess on the theory that perhaps one of them might be worth your consideration. We fully rebutted every single one of those in our responsive brief and shown that they have no merit.
Well, let's talk about jurisdiction. I didn't see that to the extent that Swing First raised issues that Johnson thought should have been before the Corporation Commission, that there were any special actions filed trying to at least peel part of those off prior to the jury getting to deliberate on the various claims that were remaining, at least at the first trial.
I'm sorry, what is the question?
Well, was there a special action to peel off subject matter jurisdictional issues?
Yes, there was.
Okay.
That was brought by Johnson Utilities, and it was denied by the Court of Appeals.
From your perspective, is there a problem with the court's jurisdiction over the claims that were tried?
Absolutely not. It's a very counterintuitive position that Johnson Utilities is taking here. They've sued for breach of contract. They've taken the court's jurisdiction. They hope to win on breach of contract. Among other things, Swing First Golf counterclaimed, claiming that the contract was breached, but in fact, Johnson Utilities owed Swing First money. And especially in the second case where the contract claims, the mutual conflicting contract claims were tried, that's all there was. The instructions that went to the jury were contract instructions. There was no evidence whatsoever that was presented to the jury that said, you've got to change this rate, you've got to set a rate, you've got to set a policy. It was simply a damage calculation. And I guess this is as good a time as any to talk about the basis for why Swing First brought up the cost of effluent. It's not for the purpose of what is being represented here, but it's simply a damage calculation. The unrebutted testimony in this case is that Johnson Utilities had ample quantities of effluent to provide to Swing First at all times that were material to this matter. And the evidence is also clear that Johnson Utilities, rather than provide that lower cost effluent to Swing First, simply pumped it in the ground. And
But doesn't Johnson Utilities get to decide as the utility, what water it's going to deliver to a customer?
I would
It may not make any sense, and it may not be, but businesses do, things that don't make sense to me all the time.
with all due respect, Judge Portley, that would certainly be a breach of the covenant of good faith and fair dealings.
Why?
Swing First,
They have, as a utility, they can send to their customer, the water that meets their need. They don't have to decide that it's the, cheapest water. Now, there may be, bad reasons for doing it, but don't they get to decide?
no, I submit they do not. And first of all, I think it would certainly be bad faith to send a customer the more expensive water. If we had that sort of discretion, we'd be setting some bad precedent for utilities in this state that basically they could provide the high-cost product anytime they wanted to in lieu of the low-cost product. They have a duty as public service corporations to be looking out for the interest of their customers. And on top of that, there is and again, this is clearly in the evidence, when Swing First was contemplating buying this golf course, they discussed the availability of effluent from a soon-to-be-constructed wastewater treatment plant. And utilities said, we'd love to provide that to you because we've got to put that water somewhere. And what you need to do is construct a pipeline so that we can deliver the water from the curb to your 18th hole golf course lake. And Swing First caused that pipeline to be constructed. Now that's offer and acceptance. And that right there is an obligation then by utility to deliver as much of that effluent as is available, not to pump it into the ground. May I go on?
Please.
Thank you. Let's talk about quantum merit and the contract price term. And I think your honors understand the issue here. We cited at page 42 in our brief 1, 2, 3, 4 cases from outside of Arizona and 1 case inside Arizona where the court allowed quantum merit recovery in the exact amount of the contract price. And this only makes sense because the party's own agreement as to the value of a service is the best evidence of what that service is worth. As to the claim that there's an illegal contract and somehow or another the Swing First is benefiting from this, the law is clear in Arizona, and we've cited a number of cases here, that the innocent party to an illegal contract may still enforce that contract or at least try to receive the benefits of those. And many of these quantum merit cases are because of a innocent party inadvertently violating some sort of a contract, competitive bidding or whatever, performing a service when the other party, and let's get to the specifics here. Johnson Utilities is charged with knowing that it couldn't provide water credits on behalf of its affiliate to pay for services that SwingFirst was providing to that affiliate. My client, SwingFirst Golf, there's no way that he would know that. You've got, first of all, the same person owning both companies. Mr. Johnson says, I'll give you water credits. And he says, okay, fine. 3 years later, 4 years later, he's saying, that's illegal. I can't pay you. That's just wrong. I think I was going to go more into a discussion about the adequacy of the evidence. I didn't see that that was really raised. I think there was certainly ample evidence to support both jury verdicts. There was discussion of evidentiary rulings by the judge. There's no showing that the judge abused any of his discretion or that the judge in some way or that the judge's ruling resulted in material prejudice of the type that's required to reverse a judge's evidentiary ruling. As far as the attorney's fees go, clearly that's in the discretion of the judge who sat through the trial to determine and evaluate the performance of the attorneys and the amount of work that was done, and then award an appropriate attorney's fees award. So unless there's more questions about the responsive part of our brief, I'll proceed and turn to the other, if I might have a drink of water before I go. In our brief, we've gone into really great detail about why the bad faith tort should be available to SwingFirst. Most of the argument in case law is unrebutted by Johnson Utilities. It's extensive. Rawlings is a very long case, and our section in the brief was quite extensive. So I'm just going to try to hit the highlights here. Courts have long recognized that in certain circumstances, an injured party may bring an action seeking tort damages for the breach of the covenant of good faith and fair dealing that's implied in every contract. That's a lot of words. I'm just going to call it the bad faith tort, like the court did in Rawlings. In the opinion in Rawlings, which is written by Judge Feldman, the court quoted with approval this statement from Prosser and Keaton. The principle, which seems to have emerged from the decisions in the United States, is that there will be liability in tort for misperformance of a contract whenever there would be liability for gratuitous performance without the contract, which is to say, whenever such performance involves a foreseeable, unreasonable risk of harm to the interests of the plaintiff. I think this is really the clearest way of looking at the bad faith tort. If a party to the contract does something gratuitous that's likely to cause foreseeable harm to the other party, that party should then be able to recover for that harm. If contract remedies are inadequate, then tort remedies are needed to fully compensate the victim. And if the tortfeasor's evil hand was guided by an evil mind, punitive damages should also be available. As Rawlings said, the final important factor which we extract from the cases is that of deterrence. In contractual relationships in which one party primarily has sought protection or security rather than profit or advantage, contract damages not only fail to provide adequate compensation, but also fail to provide a substantial deterrence against breach by that party who derives a commercial benefit from the relationship. Rawlings then extensively discussed, after its extensive discussion of the case law, concludes ultimately that this tort should be available to aggrieved parties in insurance disputes. And we understand that so far Arizona has not gone past that. But the Supreme Court didn't intend to limit the bad faith tort in that way. 5 years after Rawlings, in Berkins versus Tycor Title Insurance Company of California, and I don't know if I cited this in my brief, so I'll give the citation. That's 168 Arizona 345. In certain circumstances, the breach of the implied covenant may provide the basis for imposing tort damages. These principles are not confined to insurance contracts, but apply to contracts in which there is a special relationship between the parties arising from elements of public interest, adhesion, and fiduciary responsibility. I'd submit, if ever there was a case that cried out for the bad faith tort remedy, it's this one. A party looking for insurance has a world of options. The party can evaluate the customer satisfaction of the utility of the insurer by reading consumer reports. The customer can turn to AM Best to evaluate the financial performance of the insurer. And insurance companies do compete. I mean, I think half the ads on television now are by insurance companies. They compete on price and service, and they know that a dissatisfied customer can instantly change companies. By contrast, when it was considering buying the golf course, Swing First had only one option for irrigation water, and that was Johnson Utilities. And the price and terms were strictly take it or leave it. And once once Swing First purchased the golf course, it became Johnson Utilities' captive customer. This is the super glue of adhesion contracts. And I think the evidence is overwhelming that Johnson Utilities exploited its special relationship with Swing First in a campaign that certainly seems to have been designed to put Swing First out of business. It charged 4 and 5 times the lawful rate for irrigation water. It withheld inexpensive effluent and instead pumped it into the ground. It ran up huge phony past due balances, refused to correct them, and then used them as a pretext to cut off irrigation service. That's a death sentence for a golf course. And then, when Swing First exercised its rights to go to the Corporation Commission by filing a complaint, that very same day, Johnson Utilities began flooding the golf course with effluent. The jury in the first trial was so outraged that it wanted to give Swing First $1 million. They heard the evidence, and that's how upset they were.
But I also noticed that they decided, even though they found for Swing First with respect to the negligence and trespass claims, they found no damages. How does that, how do you square that?
I think we did a poor job of presenting the evidence of the damage to the golf course. It's a difficult thing to do, to go back and get receipts as to the work that was actually done, the fees that you actually lost. You're having almost to establish a negative in how much revenue you lost as a result of this. Certainly it was an inconvenience. Certainly no one likes slogging around through effluent. It treated effluent, but effluent just the same. I'd like to circle back to Prosser, where I started on this. Johnson Utilities' misperformance involved a foreseeable, unreasonable risk of harm to Swing First interests. They knew what they were doing, they knew what they were trying to do, and what they were trying to do was improper. So we asked this court to reverse the trial court and allow Swing First to try its bad faith claim. I have some time left I can reserve, and if I have anybody have any questions?
No, thank you, counsel.
Thank you.
Counsel?
Thank you. Just a couple of points to respond to counsel's comments. Swing First seems to be asserting that Johnson Utilities somehow waived this concept of subject matter jurisdiction, and I'll submit to the court that in Arizona, a party can't waive subject matter jurisdiction. It either exists or it doesn't. The court's identified that there was a special action filed to try to escape from the trial court and go to the ACC. Unfortunately, that special action was not granted and was sent back to the trial court for determination. As to Swing First's position that it sets a bad precedent for a company to provide a more expensive product to a customer. Well, here the customer doesn't have a right to receive effluent. That's what they're trying to establish through the jury trial. And that's the precedent they're trying to establish from a jury. Now, I'll submit a jury's in no place to try to establish precedent as to what a customer is entitled to receive or not entitled to receive. That type of determination is solely reserved for the Arizona Corporation Commission because they have the expertise, they have the knowledge base, they know what environmental impact any of these decisions might have, And they also know that they're not serving just one customer like a jury would be serving in a trial court case. The Arizona Corporation Commission takes all of that into consideration, especially given that we've got a public policy that utilities aren't to discriminate against other customers. In this case, what Swing First sought was preferential treatment. They sought an agreement or a right to only receive effluent, and that's not a jury's job. A jury doesn't get to decide that. As to the tort remedies that Swing First is seeking in this case, I'll submit that the Arizona Corporation Commission exists for providing Swing First relief in that regard as well. To the extent they feel that they're being mistreated as a customer, they have the right and the ability. And in fact, Swing First has taken that opportunity to go to the ACC and has filed several complaints with the ACC relating to rates, to service provided. They've sought relief when it came to having their service shut off. The ACC provided them relief in getting their service turned back on when they were behind on payment. And at the end of the day, the ACC is there for that purpose. So in terms of any other tort damages, Swing First asserted traditional tort claims. And they've provided no basis as to why they ought to be entitled to new tort claims that Arizona's never recognized in this context. And I don't think that Arizona should recognize them because the level of relationship between a utility and its customer is simply an arm's length commercial transaction. And if we expand it to include tort remedies for bad faith breach, I think it just opens up the doors for every kind of commercial transaction to have that type of claim. Thank you.
Thank you, counsel. We'll issue a written decision in due course. Court's in recess.